Okay, welcome everybody. Yes, there has been a new order by the judge. Good news and bad news. The good news far outweighs the bad news. The bad news is it's postponed another week or so. But the good news is there's some reasons why it is postponed. So I got Ruhif in here.
Hello.
Hello, Ruhif. And if I think Reg Rhetoric wants to come in, he's more than welcome to. I will get him the link here in a second. But I basically wanted to go over with Ruhif the order itself. We've got it from the judge, from Scott, sent us directly before anything else, and we had talked to our attorney, and we all seem to be on the same page. So awesome. So you want to like just dive into this, Ruhif?
Yeah. Yep.
All right. So this is the way I read this, is that this is a complete layout, step by step, from the judge, from start to finish of the proceedings, to do two things. One, to have no chance of appeal, and two, to have a very solid case to the district attorney. And so he's just laying everything out step by step, and he's giving Kyle till November 5th to do certain things that Kyle said he was going to do, which we all know that he'll be unable to do. So we'll go through this. One, plaintiff served the civil summons and complaint in this action on defendant Kyle Curtis on August 30th, 2019 by delivery of certified mail to what plaintiff contends was the Curtis place of residence. See service of process, etc. Curtis' mother signed a certified mailed receipt documenting delivery of those mail materials to her at that address. Now, this is very important to Rule 4, to raise the presumption of service. Rule 4
Correct.
states explicitly it must be certified mail. Doesn't have to be registered. That was changed like decades ago or something. But it was by certified mail, return receipt, and that a person of reasonable age has to sign for it. Not explicit, the exact person, but somebody of reasonable age. That's called the agent. And the person is an agent when they signed for it and they give the papers to the addressee, which in this case was Kyle. So she became an agent by law when she signed for it and gave Kyle the papers, correct?
Yeah. So simply signing for the return receipt and then us filing an affidavit with the court saying that we've got the return receipt, we sent it by certified mail, raises the presumption in Rule 4, raises the presumption that she is an agent, and then basically to overcome that presumption, you have to show both that she was not your agent and that he did not actually get the papers.
And merely
So
to saying she was not an agent
not.
is not good enough.
Yeah, literally just filing an affidavit from Kyle and from his mother, just saying, I'm not, Susan Curtis is not Kyle's agent, has, there's plenty of case law that says that's not enough. It all comes down to whether he got the papers. If he got the papers, then clearly she was an agent. If he didn't get the papers, then clearly she was not an agent. So it all hinges on whether he got the papers.
Right, and that's one of the reasons why it is one of the reasons why the judge had the depositions, to find out if there's any credibility to his last affidavit where he said he didn't get the papers.
Correct. Yes, there were two reasons to do these depositions. Number one, to test the credibility of the statement, did Kyle Curtis get the papers? And number two, to resolve the perjury issue. I mean, clearly, with the affidavits of Ben Potts and Kyle, someone is lying. There's literally no way around that. So the judge needs to know who's lying, and then he'll make a referral to the district attorney.
Yeah, it may or may not have been perjury per se. It would have been at probably the minimum what's called a filing of a false statement. The deposition itself, however, that is straight up perjury. Straight up perjury. And we'll get into that, why the judge did that. Ghost to Recon, $5. Hey, Steve, keep up the good fight. Thank you, Ghost to Recon. I appreciate it. All right. So number one is basically, this is getting out of the way the fact that this is per Rule 4 that Kyle was served properly. Okay?
Oh, the presumption that he was served properly, which you're right, can overcome. Yeah.
The presumption, you're correct. Correction. The presumption of service, which he can rebut if he could show that he didn't get the papers. That's it. That's really it. It has nothing to do with where he lived, by the way. That was going to credibility as if he got the papers, but where he lived does not matter. All right, number two. On October 3rd, 2019, this court made an entry of default upon the plaintiff's proof of service and Curtis having not timely responded, which is just saying that there's already been a motion on it, right? There's already been something that the judge has sent to Kyle at his mother's address that he was in default, and he was given he was given notice of this.
Yeah, he knew about it because he was in Discord on October the 6th, I think it was. People are asking, like, why did you not respond? And he goes, I was fucked in the head or whatever. So he obviously knew about the court case in September, and he obviously knew about the default very, very early after it was lodged.
Yep. Number 3. On November 19th, 2019, the court attempted to provide Curtis with notice of the motion of default judgment through its posting of the court's electronic docket and by mailing a copy to Curtis at his last known address. By the way, what does that say right there? What are those words there?
Hang on one sec. I'm talking to Intrigue Feline. What'd you say?
What are those words that I highlighted?
Hang on. I'm behind on the stream. At his last known address. So that's really the court. That's the court kind of having a stab at contacting him, saying, look, we are going to give you a default judgment. Do you want to, do you have a chance to respond?
Yeah. But people are already like, oh, well, you can't use last known address. Yes, you can. We've long established this. The whole narrative went to, again, Kyle saying that BS and, oh, well, Steve had me served at an old address and he knew he was, and him and Ruth got together to conspire to try to get a default judgment. I mean, absolute nonsense. First of all, it was...
If he got the papers, it doesn't matter where he lived. Intrigue Feline says, so in terms of the filing a false statement versus perjury, Intrigue Feline says there are several affidavits filed with the statement under penalty of perjury.
That's true, but it's easier to prove filing a false statement if there's multiple witnesses, right? In a deposition, you're sworn under oath with witnesses. That that raises from a Class I felony to a Class F felony. And so yes, they could go after him for perjury under perjury, but it's a lot easier to try to if you're going to prosecute somebody, it would be a lot easier, from what I understand, under a false statement rather than the actual criteria for perjury, right? Could it be elevated to that? Yes, but it's one of those like manslaughter versus homicide versus murder. There's different degrees, although they're still all killing somebody. These are all still lying under oath, but from what I've read and when I've talked to people, filing a false statement would usually probably what they would go over. Perjury is it's one of those crimes that they don't prosecute very often, which this
I've seen a few. I've seen a few, and I've seen a few let go as well.
Right.
This is so egregious and so blatant. It's not going to be let go.
And that's why they wanted the depositions, because it was more than just filing a false statement on an affidavit, which again they don't generally go after, but the depositions they do. All right. So
and the forgery is blatant and egregious and brazen.
Yeah. Well, we'll get into that because that's one of the reasons why the judge is asking for what he's asking for. He wants that forgery charge. Although he contends that he had not received the complaint and summons by this time, other materials of record now demonstrate that Curtis had become aware of the lawsuit having been filed against him before the court entered any default judgment. Okay. Now we will obviously say just having knowledge of the case does not constitute proper service. We've never argued this in the court. His lawyer tried to argue that. The judge shut her down pretty quickly on that. Correct.
Yeah. All this is saying is that he knew about it very early on and took 5 months to respond to it. So when the judge, so Scotty Forbes-Lee in the hearing is saying, his, case law is Steele versus Estate of Teal versus Derby, blah, blah, blah. All these case law saying, even if you respond late, you should be given the opportunity to overturn a default. And, James Gale, legend, goes, I don't think you should get the liberality of this interpretation because he's had 5 months. He dicked around for 5 months rather than responding to the court in a timely fashion. So he does not get that benefit of the doubt.
The next sentence is something to the effect, but it cannot be ignored. The defendant's ignoring of business responsibilities, or I remember how it's phrased, but basically saying that, hey, look, if the defendant doesn't do what they need to do, that cannot be ignored. The plaintiffs have rights too.
You can't just wait. You can't just sit around and wait for the default judgment and go, oh, I don't really like it, and I'm feeling better now, and I might respond. The judge was quite explicit. He will not get the liberality that the particular precedents that Scotty Forbes Lee cited afforded those particular defendants.
Mr. President 99 has two questions, and they're good questions. One is what is the difference between jail and prison? Jail is generally a holdover. For example, if you get arrested and you're waiting for bond, that's usually a county jail or some kind of jail. A prison is actually usually after you've been sentenced, convicted and sentenced, tried and sentenced. And how much is Kyle facing? I did the math on the different levels of felonies. At maximum, I mean, this is if they, it depends how many counts he gets. But I mean, if they went for max, it would be 15 to 20 years. But do they do that? No. Let's be realistic. Obviously, we don't know how many counts there'd be. There's clearly one count of forgery, maybe two. And clearly one count of perjury.
Well, no. There's at least two counts of forgery.
Two signatures.
Plenty of counts of. Not even including the lease or the affidavit from Potts. I mean, that's more.
Yeah, but the other ones, I don't think they're going to file under those on a forgery. I would think they probably would file under those or submission of false evidence or altered or tampered evidence.
So there's the ECF 20 filed in February that has forged documents in it. And I don't know whether each individual document is a count of forgery. It may just be each individual swearing in kind of thing.
And it depends on the state. And I talked to a couple people on that, and it's there's no way to know. That's up to the discretion of the DA. But I mean, he in theory could be 15 to 20 years. Now, is he going to get that? No, he'd be pled down. They don't like to have these things go to trial, obviously. I think that if he got 3 to 5 years, it would be about reasonable. Does that make sense to you?
That'd probably be a reasonable sentence, and he might serve 2 or 3 or something.
Yeah, but with priors, that might be a little higher.
Yeah. His prior record will severely F him up.
Brilliant says, has a judge allowed Scotty Forbes Lee to leave yet? No, that will we'll get into that. So, all right, well, hang out on the questions, guys. Hang on to the questions, okay? If he goes to jail, it'll be for contempt of court. If he goes to prison, it'll be for the crimes. All right. On January 23rd, the court entered a partial default by judgment by default, having received no filing by Curtis challenging either service, the entry of default, or plaintiff's motion of default judgment. He did not respond. That's what this is. He's just saying. They're just saying he had the opportunity to, and he did not take the opportunity to respond.
Yeah. Also, during the deposition, so after the default was entered, so in October, he had been talking to Katie Joy Paulson. Katie Joy actually did a video in, I think it was the middle of December, showing some text messages from Kyle. And in one of those text messages, Kyle said, I've been receiving a couple of mails from the court. So clearly that responds to the court trying to tell Kyle that they were about to do a default judgment.
Correct.
Do you want to respond or not? So that text message is pretty good evidence that he did receive it. And in the deposition, he basically said he was lying to Katie. So,
on a deposition about credibility, he's talking about lying.
Yeah.
That you just can't make this up. Benjamin Potts, $5. I'm sending you money, Steve, so that when Unicock subpoenas my bank statements, he can see who paid who. Great. Now it's official. I have literally made more money off Kyle's ex-boyfriend than I have Kyle. Wow. Thank you. That's God. Oh, man. On February 6, 2020, Curtis filed his motion to set aside default judgment. Curtis therefore amended his motion and filed multiple affidavits and documents to support his contention that he no longer resided with his mother at the time of service, but was rather living in Charlotte, North Carolina with Benjamin Potts. On July 28, 2020, among other materials, Curtis filed his own affidavit. That's actually pretty... Do you read this the way I read this? That he filed it without Scotty Lee Forbes doing much on it?
Yeah, I don't quite understand that. On July 28th, among other materials, Curtis filed his own affidavit.
Yeah, I don't know how to read that, but I'm not going to read too much into it. But I did say before that it didn't seem to really have much to do with that last one. It was like, I don't think
I would say that she might. Hey, how are you? I would say that she like that. Isn't that the one where she's just like, here's what my client wanted me to file. Thanks. Bye.
Yes.
And it's basically that was her affidavit on that affidavit, basically.
Yeah, I wonder if he just filed that, just said, here, file this. I don't know. But a document purporting to be an affidavit from Potts affirming that Curtis lived with him at the time of summons and complaint were served. No, actually, was this one before? This was one before, wasn't it?
Yeah.
Because the last one was August.
Put a pin in that one and work it out later.
A lease bearing purported signatures of both Curtis and Potts, and a Discovery Bank statement purportedly mailed to Curtis at Potts's home.
Yeah, notice the use of purportedly everywhere. The Discover subpoena and the Zell subpoena have both, the responses to those subpoenas have both been filed with the court. They've been filed under seal, but the redacted versions have been given to us, and Scotty Forbes-Lee has not objected on confidentiality grounds, which is why we were able to share them.
Correct.
It still has no bearing. You can file anything under seal. I mean, if it's obviously contains no sensitive information, then the judge will go, why? But it's there's no breaking of the law anywhere here.
You mean Unirock's wrong on that? I mean, he's such an expert in legal matters.
Yeah. The fact that it's under seal, we can still share a redacted copy because we have waivers from Scotty. And obviously
she did not object to that. Reg Rhetoric, $5. Remember the 5th of November.
Nice. I mean, I tweeted my email to Ben. So my only written communication to Ben was my email offering to pay for his legal fees. That is sealed with the court, and I'm well within my rights to waive confidentiality on that. And I posted it on Twitter the other day. So
there you go. Yeah. On September 9, 2020, plaintiff filed an affidavit by Potts testifying that Curtis had forged Potts' signature on both the affidavit lease Curtis had filed in support of his motion, and that, in fact, Curtis did not live with Potts in Charlotte at the time the complaint was served and had not paid Potts rent. Plaintiff also filed evidence which he contends proves that Curtis materially altered the Discovery Bank statement to falsify a claim that it had been mailed and received by Curtis to Charlotte at Potts' residence. Now, keep in mind, when this goes to the DA, all this is nicely just boom, 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 right? I mean, obviously the DA is going to do a lot of stuff, but this is a chronological thing where they can just go through it and get a really good brief overview of everything right off the bat, I think.
And they'll have the Amazon subpoena back as well. So
yeah. Mm-hmm. Curtis, number 8. Curtis has contended in Potts as denied that Curtis made a rental payments to Potts in July and August 2019 through the Discover account. Now, go ahead, Riff. I mean, people already know this, but what's the problem with that right there?
We subpoenaed Zell and Discover and Amazon. We've received the Discover and Zell subpoena responses. They are clearly showing that Kyle forged documents. So there's no allegedly about it. They're forged.
Yeah, the Discover account wasn't even open to October, meaning that the only way there was a July or August statement for Discover, July was for the Zell that through these Discover, and August was an August statement. It was if Kyle had developed time travel. That is the only explanation. So yeah, that is confirmed that those have been altered. There's no question about that whatsoever. The judge is aware that they are altered. Schroeder's Cat for $2 says, I hope to debate on the revived non sequitur so soon. Thank you very much. We'd like to have you on. Having reviewed the contradicting sworn statements, the court advised counsel that it believed depositions of both Curtis and Potts should be taken. And we did not object to that.
Yeah, purely to decide the credibility of Kyle's statement, I did not get the papers, and to also, flesh out a DA referral, basically.
Yeah. On the 22nd, 2020, transcripts of the depositions of Curtis and Potts, together with multiple exhibits, were filed, the Moab. Each continues to challenge the testimony of each other in material respects. Curtis testified during his deposition that this is where it starts getting, I think, really good. This judge knew what he was doing. Curtis testified during his deposition that he has or will soon have additional materials to support his position, but that he would only provide them to his counsel, not directly to Potts or Potts' counsel. Those documents included bank statements from Discover, original electronic files from Curtis affidavits filed with the court, and other materials. Now, again,
what is he going to do?
Let's remind people that he didn't have the Discover account to provide the actual original August statement that he submitted to the court.
So we asked him for discover statements from, I think, June 2019 to September 2020, and he only provided us with statements from February 2020 onwards. All right, and when he was asked about it, what did he say? He said,
no. He gave us November too. We did get November.
Did he?
Yeah, because the November one had actually been altered. Yeah, we got the November one. We didn't get anything prior to November. From the not from Kyle. Oh no, I'm sorry. No, you're right. You're right. You're right.
Yeah, sorry.
Kyle only gave us
February 2020.
I'm sorry, my mistake. Kyle only gave us documents February 2020 on, but Discover gave us October, November.
From October.
Yes, from October. So that was really telling, by the way. All right. So he says he was going to give us the originals going back to where, we wanted them, which is back all the way to July. Guess what? The Discovers don't exist. It's not physically possible for him to do that, clearly.
Yeah, so my video where I go through the whole touch-up text edit thing, and I show that the November statement, there were bits and pieces of forgery here and there, but the dates of the transactions were basically not touched, but the address was touched and a few of the values and whatever were touched. But the statement period and the dates of the transactions were not touched. So that was a legitimate November statement, whereas the so-called August statement with the touch-up text edits, you could see that he changed the statement period from whatever to August, and then changed all the transaction dates from whatever to August. And then I work out from the data matrix code that the statement was made on the 1st of November, which implies that it was an October statement. And that makes sense given that the response to the Discover subpoena was that we only got documents from October onwards. Right. So he's obviously changed an October statement to look like an August statement.
Which we've said from the beginning. Contrary to anything about holding back anything, no. Kawasa 10,001, more donations for the V-Day Parade. Thank you, Kawasa. Yeah. Appreciate it, buddy. Bunny Wabbit. I love that. I love her name. Bunny Wabbit. I get to say that all day. That's how I used to talk, actually. I mean, people know I have speech issues growing up. I could not pronounce my R's. I still can't roll my R's to this day, so I was always like Bunny Wabbit. So I have an affinity toward her name. So Bunny Wabbit says, I just say that all day long. It is the August statement that the judge wants. Yes, Kyle said he would produce the originals, including the August statement. Now that, of course, is impossible. Yeah, it's impossible. And it was during a deposition, which means that it is clearly perjury. Perjury. That's what the judge is looking for. Because
if you can tag both Steve and I in the chat, and we'll see messages or questions easily.
Yeah, that'd be awesome.
An intrigue feline from a while ago. Did you also file the response statement from Discover pertaining the lack of records prior to October? I think one of the sealed things was emails between us and Discover, and I think that would be the email saying, there is no August.
Yeah, we have that. I've actually shown that publicly. That email is public. That was something that my lawyer said we can show, even though it's under seal. I think
even though it's sealed.
Yeah. Yeah, again, I hate to say it, but Unirock doesn't know the law.
Question further up from Icarus. I heard North Carolina has a 3-strike rule. Wouldn't that F Kyle even more?
That really only goes in North Carolina. It only goes for violent offenders.
Okay, so it was break and enter, and I thought so he had to break and enter into a church for some silly reason.
Yes,
I assume that's a felony. Yeah, but the cocaine possession that sort of broke his parole, I understand it's not a felony.
The cocaine possession was not a felony, but breaking his parole turned it into a felony, from what I understand.
So even if there was a 3-strike rule, he wouldn't qualify anyway.
Yeah, but they don't do 3 strikes for white collar, nonviolent kind of stuff. Yeah, that's not what it's for. It's not, but there is a thing for habitual felons, but that's a whole different thing. Right. Curtis' motion is now before the court for ruling. The court wishes to make its ruling only after being satisfied that Kurt has been given adequate opportunity to file the documents that don't exist. He contends supports his position, which the court considers potentially relevant to the court's assessment of credibility of the competing witness. This is called closure. This is called completeness. This is the judge saying we want to make sure there's absolutely no chance for appeal, that everything's laid out, and because Kyle said in the deposition that he had them, that when it goes to the DA, that actually will be brought up. That actually is a element of the crime. So, the way I would say it, that's probably not legally. I'm probably saying that legally incorrect, but it does make a difference to the fact that he said that he had the thing under deposition oath. He does not. There's competing witnesses. There's a testimony that says it's forged, and that in and of itself would just be like a he said, she said it. But because he said he had the originals, because he says he has documents he produced, it is no longer he said, she said, and it's just it's going to be used in prosecution.
Yeah, the best part of the deposition for Kyle, I think, was when Scotty Forbes Lee asked him to reaffirm that none of these documents are forged.
Yep, and oh man, I couldn't believe it. The person who sent me the Amazon thing, which by the way was not Todd. But the person who sent me the Amazon thing, she was watching that, and she was amazed how easily Kyle lied when Kyle was sitting there saying, well, like he was watching your thing, right? Your video, and he's like, oh man, I was watching this, him drone on, and by the time it got done, I was going to turn to Scotty and say, well, maybe I did forge it. He lies so easily, right?
I was stunned by that. Like he's a very good
blatant liar.
Yeah.
Going to Unicorn 5 New Zealand, Kyle must be very proud of his, quote, creative skills now. Skills he bragged about and used as reasons to kick Steve off a channel with a 50-50 partnership. Yeah.
He's a bad forger.
He would make a very bad counterfeiter forger.
Trevor Lund, an updated thought from a fellow Aussie that your health continues to be as robust as you want it to be. It is. I'm good. Thank you.
You sound good. You really do sound good. The court directs that Curtis shall have until 5 p.m. on November 5th, 2020, to file those additional items that don't exist, identified in his deposition that he at that time intended to produce or file. But for those specific materials, the court deems this record on the motion closed, absent further order. In other words, we don't have to do anything else.
Yeah, let's go through Kyle's options here. All right, with respect to the Discover statements that he didn't turn over. So supposedly August through January. Right?
Can I point out a very important part about that sentence? The motion closed means they're not setting aside the default judgment.
No.
The motion closed means that, hey, you're wrong, and my default judgment stands. That's what that means.
Well, it's more, I think
it's not being ruled upon. It's just we're not accepting any more briefs or motions or affidavits.
Right.
So, okay. I just wanted to clarify the meaning of that statement.
Yeah, all the judge wants at this point is Kyle said he has some original documents that don't exist, and he's giving him till the 5th to produce them. Now, that is because, one, for any kind of appeal, that shut it down, and two, when it goes to the DA, they can say, we gave Kyle Curtis ample time to produce these documents. He said under oath, again, under oath on a deposition, not just an affidavit, but in a deposition, elevating it to a much higher degree of a felony.
Yeah.
So, and what are his options? So there are these, non-existent August, September Discover statements, and then there are the Discover statements from October, November, December, and January, which would have his Pleasant Garden address. What are his options in terms of turning those over or not turning those over?
Well, okay, let's look at that. Kawasa 5001, certainly not as proud as Unirock and his investigative journalism at Going to Unicorn lulls. Yeah, Unirock hasn't figured out that he just was wrong from the get-go. He's trying to blame it on other people. He's literally trying to come up with the most ridiculous spin in the world to his idiots that listen to him. I mean, he's just like the Alex Jones of the internet at this point. But all right, let's look at his options. Because here's the funniest part. He already knows that the judge knows that the account wasn't open until October for Discover. So he knows he's boned on that, right? He's just boned.
Yeah, he knows the legitimate Discover statements have been filed with the court from Discover.
So you want to finish this last thing and then we'll give the options, or you want to do the options first?
Yeah, keep going. Yeah.
All right, so because this last part is quick. Also, on October 22nd, 2020, Curtis's counsel of record filed a motion to withdraw, stating that Curtis had not yet stated his position regarding that motion. Should Curtis elect to respond to that motion withdraw, he shall do so prior to 5 p.m. on November 5th, 2020. So what this means is that she is still his lawyer, but under Rule 1.16b, there has to be very specific conditions why a lawyer can withdraw. She has met this. She's cited 4 different things, but she also noted that she could not get in touch with the client. And there is one thing on what's called undue hardship, I believe, on the client, is I think what it's called. But if there's going to be some issue with the client where a lawyer can't withdraw without having a problem with the client, then the judge can weigh into that. And he has not said anything one way or another. So if he doesn't say anything by the 5th, then it's guaranteed that he's going to approve her motion. He'll sign her proposed order. I think he'll do it regardless anyways. I don't think there's anything that Kyle could come up with as a reasonable argument to say that she has to maintain the attorney-client relationship that they have. But going back to the other one, go ahead, Riff. Tell us the options he has, because I only come up with 3, and the third one is pretty much not going to happen.
So, Intrinsic Line pointed out the pages where Kyle reconfirms that he did not forge. So, Mr. Curtis, you've been pretty open about your past felony convictions from when you were younger. Curtis, yes. Having that background, do you understand the consequences for breaking the law? Of course. You understand that there would be consequences to pay for forging documents in a court case? Absolutely. Is that a risk that you would be willing to take? No. One time spending in the legal system is enough for me. Is that a risk that you took in this case? No, absolutely not. Scotty, did you forge Mr. Potts's name on the rental agreement that was produced, that was submitted to the court in this lawsuit? Absolutely not. Did you forge Mr. Potts's name on the affidavit of residence filed in this lawsuit? Absolutely not. Did you forge or alter any Discover Card bank statement that has been submitted to the court in this lawsuit? Absolutely not. Have you forged or altered any other document that has been submitted to the court in this lawsuit? Absolutely not.
Now, keep in mind on this. I want to say Gary Bronson, $5. Thank you, Gary Bronson says, Miss Forbes, which reason are you citing for withdrawing? Yes. That's actually pretty good. Yeah. She cites 4.
Disappointed that she didn't actually say to the court, he's forged evidence. That's how I understood Rule 3.3.
No, I look more into that. She really can't. She still has to maintain the attorney-client privilege. She cannot. She cannot.
Rule 1.6. She can break it.
No.
She's obligated to break it.
No. It's not. It doesn't really work that way. I've really.
Right, I'll talk to you.
We'll go more on that. She has an obligation to the tribunal too, but she also has an obligation to her clients. So what they do, they play this little game and dance. They say, look, I cannot disclose to you the attorney-client privilege unless he's actually going to do a crime. Then that's the case. But if he's already committed it, she cannot violate that. So what she does, what attorney does, is say, look, I have an obligation to my client and the court. I cannot proceed on this. I am in an impasse situation. Therefore, I cannot proceed. Don't ask me more questions about it. And the judge usually goes, yeah, we understand these types of situations. There's actually 3 things that they have an obligation to: the court, the client, and to the law. So
I'm sure we'll fight about it later.
I'll beat you, man. I know where you live. All right, Athens 619, $5. Jason must be the best buddies with Anthony Riley in the Pathological Liar Club. Yes.
Yeah, just so people know, Riley, so Sleeping Warrior, Flat Earther, sort of by proxy, took Ranty Flat Earth to court over some super chats. Riley is not a good lawyer. He is a qualified lawyer, but he's just not very good. Basically claiming that some super chats were meant for Roxanne, the globalist denier, when it was explicitly clarified later that they were meant for Ranty. Riley's magnificent legal theory failed, and Ranty won the court case. There you go. BT Toast says, can you read page 83, lines 7 to 19 on Kyle's deposition? That was the best mic drop in the whole deposition. Let me get it. 81, 82.
Elsie, $5. Congrats on a promising order. Thank you, Elsie. Yeah, again, this is actually really good. It just sucks it's another week, but I want people to recognize why the court's doing this. They're giving Kyle a week just so they can say, hey, we gave him a week. He didn't produce it. We know he can't produce it. This is a given. This is an impossibility.
All right, let me read out this statement. So BT Toast said this is the best mic drop in the whole deposition. All right, so question from Scotty, I think. I think it's Scotty, maybe not, I don't know. Question, if any mail came in, what would she do with it? Sometimes she puts it off to the side until I come by there, but I mean, she doesn't know who, like documents that are from what. She doesn't know, like she doesn't look at it like that. Question, she doesn't throw it away? Answer, I don't know. Question, do you ever instruct her to throw it away? Answer, why would I do that? Question, good question. Answer from Kyle, I'm going to take a bathroom break.
But okay, so keep in mind though, when she was asking him all those questions, because we can safely say it is a absolute physical impossibility for him to produce the discover from anything prior to October. You agree about that, right?
I think that was Scott Myers questioning Kyle there about mail.
Okay, so Scott was asking him. So we know that he lied there. When you're in a deposition and you have multiple lines of questions and you outright lie about one, that puts that basically the court can say, look, we can discount every other thing you've said. Right, it makes it incredulous for all the other things that he said. So when he said that he didn't forge it, that means nothing. That is basically dismissed at that point, because the judge can look at it and say, hey, you lied here, therefore I can use this to infer that you have no credibility about any of the other statements, which again can be going to the DA, because the DA will do the same thing. Well, you lied here, we can't, we can't take anything you say as being credible at this point.
Oh, his credibility's shot. It's he's clearly forged documents with the court. So yeah, zero credibility. I mean, Robert Beatty is out there. I mean, he's quite welcome to not come to a conclusion that the service issue is over. I'm very curious about why he can't get there on the current evidence.
I don't either.
The judge hasn't ruled,
and I can't understand why he can't get to where it is a physical impossibility to produce documents that don't exist. I mean, that's just common sense. I mean, this Beatty does not have any common sense. I had heard he is a younger creationist. I don't know if that is true or not, but he definitely has that mindset. I heard he was. I heard he hates Hovind, even though they're both younger creations. Again, I don't know if that's true. Yeah. Somebody check into that for me, but it doesn't really matter. He has the mindset, the same inept ability to understand a lot of things, and he thinks he's so brilliant, and it's just it's unreasonable to withhold affirmation or withhold confirmation of something in light of overwhelming evidence. That is just as irrational as being it's like the gumball thing. Look, I could be agnostic on it because it's 50-50, right? But if there was a million blue gumballs and one red one, and somebody randomly picked one, then I'm going to believe that it was going to be blue, right? I mean, just overwhelming odds. He won't even go that far. He just has no ability to formulate a rational, inductive conclusion. Okay, I'm going to try to pronounce this right because she mocks me. Is it Elsie?
Elise.
Oh, Elise. Oh, Elise. Okay, Elise. I'm sorry. Elise. I got it right, Elise. $20. No longer surprised by the lengths he goes when he tries to cover up his lies. I am just glad he was legally caught in this time. And Elise, do you want to kind of, don't do it. You don't have to super chat. But Elise, do you want to mention to people maybe your relationship to all this? Because you kind of have a relationship to this case. All cards on the table, but you don't have to put out too much information yet if you don't want to. Little Kitty and Ruhif, and the judge is giving Kyle time for due process. Yes, absolutely. Atheist pastor, the one person on the internet this is like more than I am. I love you. This must be fake, otherwise it would prove Unirock was wrong. Clearly, Steve stole Kyle's time machine and stole the papers that were served. That sounds legit. Yes. Go with that. But so you guys, I mean, you guys kind of see what we're going with this. I don't know how anybody at this point could have any other position. I just can't see it. If they do, please, by all means, contact me. But you guys definitely can see that people like Unirock has just lied their ass off. And there's just, yeah, and we told him, we showed him the evidence that Kyle forged this stuff. You, Riff, and I have said we know how it's going to end. We know what's going on. We have legal counsel that are not idiots, and so I don't even know what to say. I'm just kind of at a loss.
Yeah. Like we said, since the barcode and font issue, we've known that they're forged, and then the touch-up text edit a couple of days later, it's been over for a long time.
Oh, this is I gotta show this here in a second. Go ahead, and Cool, you got anything to add? Because I got to download something.
I was gonna say the delay is literally there just so the judge can say, yeah, we gave him a chance. And he didn't take it. We gave him so many chances. It's just my opinion, but I think the law is being very lenient as far as granting chance to. It's not.
I don't know if so much a
Kyle.
Chance. It's for completeness. The judge wants an airtight case.
It is completeness. Yes. It is completeness, but it's apparent to anybody who's looked at the evidence, and I'm sure it's apparent to Judge Gale.
Oh yeah,
quite certain.
Yeah. I'll read out Elise's chat. You're welcome to share, but yes, I am a CPA who knew Kyle from growing up. He borrowed money from me to never return it, and then asked me to be his CPA for free. I turned it down. So we believe that when Kyle said, this is my CPA, he's referring to Elise.
Very early on, right? Very, very early on, we knew he was. I thought there was always a kernel of truth of certain things, and I thought he was talking to a CPA, just like he was talking to a lawyer, which ended up being Nate, as I suspected, I think. But he didn't ever hire her, right? He didn't have an actual CPA. He was just he wanted to, but she said, no, you borrowed $7,000 from me, and you didn't pay it back because you're a thief. Which, by the way, Elise, would have nice been to know back then. Just saying, would have been nice to know yesterday. But yeah, no, I mean, so she actually, is involved in this, and she's saying the same things we have said. He is a thief. He's a liar. He's a manipulator. He's a narcissist. And he basically, he got caught. And this is the ramifications of that, is that the judge is not playing games with them. The judge has said, the longer this goes on, the more harsh it's going to be. This isn't even dealing with the contempt hearing yet. So
yeah, if Kyle gets to a contempt hearing, like if he hasn't turned over everything, he will go to jail that night.
Yes, if he shows up. If not, have a bench warrant out, which makes it even worse.
Yeah, we didn't actually talk about his options for turning over these documents.
We have not. But before we do that, I do want to show the audience this. While you're coming up with the three things, would you rather? Here, see here. I'll show the internal here. Do you guys see this? This is a. Can you see that?
Would you rather?
That's really good.
Pretty cute photo, actually.
Yeah, I'll give you props for that, Cheshire. That is actually really brilliant.
Yeah. Eye candy, as they say.
Yeah. Well, my answer. I'm not going to even answer either way because. All right. So, what are the three options?
Three options, right. So he said he has these documents to hand over. So the early Discover statements, along with the supposedly original signed with a pen lease agreement. So his options are, well, particularly with the Discover statements, right, because they're obvious forgeries. He can either turn over legitimate, unaltered Discover statements from August through January. Clearly, Kyle's not going to do that because he is a narcissist.
It would also be self-incriminating. I don't know if he would. I don't know what he still has a lawyer, technically speaking. I don't know if she's really going to advise him, but I don't know if that would be considered to be incriminatory at that point. Eventually the DA is going to prosecute, and he'll have to either turn over or either way he's screwed. But I think that. Do you think that by him turning that over, would it help him at all? I don't see how it would.
Probably not. Like, there's not much point copying to a crime when it's already been proven.
Yeah. I mean, it's 100% certainty that he committed a crime. There's just no question about it. So why would he turn anything over? I don't see why it would help him at all.
So there's the option of turning over legitimate unaltered documents from that early period. There is the option of turning over more forgeries. So he could turn, like, he's already, supposedly turned over August and November. So maybe he'll try and turn over September, October, and December and January with forgeries in them. So forging the date. That will obviously be another count of, a count of forgery or perjury.
But that wouldn't do him any good anyways. He still couldn't produce the original August one. I
can't. Yeah. So there's that option. And then the third option is to do nothing. And if he does nothing, then obviously the judge will make an inference. You said you had these and you didn't hand them over. My inference is that you don't have them. And you fucked three ways from Sunday.
Yeah. So go to Unicorn, a heart for $2. Thank you. Go to Unicorn. Love you. Moon with a face and hearts. Thank you, Moon. Love you too. So any option that he goes with, he's done. That's what this judge is probably pretty much saying to him. There's no good way out here. Anything he does is just either going to make things worse, or I think he's going to do nothing. Obviously, I don't think he's going to do anything. And he's just going to cover himself up under the blankets. He'll maybe try running to California, which will extradite him. He will have federal charges after they're filed, and he doesn't return. They can actually, I think, go federal. But this judge is not playing games with him. So anything he does at this point will just make matters worse. And look, my advice is always going good. Here's my advice, and Ruf, tell me if you think it's good advice, and I'm being objective as possible. He needs to get a defense lawyer. He needs to at least start looking at a defense lawyer. He turns everything over. I mean, and there's a lot of stuff to turn over. He has no idea, I think, everything involved to turn over to avoid a contempt hearing. Turn it all over, and to basically throw himself on the mercy of the court. Red just said the same thing, and I wasn't even looking at it. And come clean. Then again, there's a problem with that by admission of guilt. And a defense attorney would probably tell him not to do that. But he needs to hire an attorney that will do this all for him.
How's he going to pay for an attorney? Like, who's going to fund his attorney?
Whatever. Unirock can have a fraudulent GoFundMe fee. Well, actually, it wouldn't even be fraudulent at that point. He would actually have a legit one. It would be.
Oh yeah, you'd have to say, look, my
spend
friend
the money
Kyle
on Kyle. Knock yourself out, people. I think it's a freaking hilarious that people spent $5,000-$6,000 to get him a lawyer, and all it did was help us. The burn on that, it's gotta burn them. Come on, at least a little bit. I think.
Oh, I think it was Stina or someone said they donated $1,500 and they're feeling pretty dirty. And I was like, yeah. Who was it? I think it was Elizabeth Richardson as well, who donated after it became clear that there were forgeries. Clear to us, but clear
like
to reasonable people, but not clear to some unreasonable people. She donated after the forgery was obvious. And I bet now she's kicking herself.
But here's the thing: it's not like I didn't warn these people. I mean, I swear to God, I'm telling you, if somebody's going to go, oh, look, this is Steve being a narcissist, when it's not. This is me being a realist. Had people had just listened to me from the beginning, especially Kyle, we would have never been in any of this situation, and Kyle wouldn't be facing prison. If just any of them would have listened to me, I've been right all fucking long. It's infuriating, the fact that when you have the information, you have the truth, and people don't want to listen to you. Now, do I really care? No, because it ended up being in my favor. But the point is, though, it screwed over a lot of people. It really affected a lot of people, and you still have people like Unirock still trying to profit off of it.
Honestly, I honestly think of Unirock's audience as flat earthers.
Yes, they are.
They're equivalent.
No doubt about it. Or at least Alex Jones level, definitely.
Oh yeah.
Res Instance, thank you, Res, my buddy. We gotta start playing some games again, Res. $10. Feel the burn. Thank you, sir. But I definitely think that's the takeaway from this is that, look, I may not always be right, but I'm going to give you the best possible information that I have, and if I get it wrong or get new information, I'm going to correct it. Unirock doesn't do that. A lot of content creators don't do that. And I want going forward on this channel and the Non Sequitur show for people to know that they're going to get the best possible information that we can provide. Again, we have science people all the time. We may not always get it right. I'm telling you, but you know that at least we're going to try, and we're at least going to fix our mistakes. That's all I can ask for. That's all I've wanted from the beginning. And I don't know why a lot of them haven't quite figured that out by now. If your track record is pretty good, like I said, go look at my Twitter line from the show that we had today with Cheshire for Caffeine Corner. Steve, go look.
Steve, you're a meanie poopy head, so
but I'm a right one. I don't know. Go look at my Twitter and look under fun fact under my name and go find how many fun facts I got wrong. And I think it's pretty low to say the least. I really so. Elise said to be fair. What am I saying this wrong?
So I typed it into the chat. So less emphasis on the so and then Elise. Yeah.
Think for Elise.
All right.
Think for Elise.
Oh, I love for Elise. Yeah, I could actually play that song. Elise. To be fair, I was hoping that he had turned a corner and wasn't sure if I approached anyone. Hindsight 2020. Yeah, you didn't, which is fine. No, I'm not. Definitely no responsibility to you. No blame at all to you. But yeah, it makes sense now, right? Because again, looking back with the pieces falling into place, okay, when we were saying, well, who's this person we need to contact? Because he kept telling me, well, you know, my tax guy, he called you a guy, by the way, my tax guy or my CPA will I'll get you the information. They'll reach out to you. And then the most beautiful part was he kept saying, well, you know, my tax guy says I can't give you the funds, and then ran some bullshit narrative about, you know, oh, Steve can't get this money and medical. I'm like, give me my damn money. I don't give a shit.
Did I hear once that the accountant was holding the money?
Yes. Well, he said twice. He said once. He said the CPA was not allowing him to distribute the money, and he said he had it in a separate account available to me at any time, which was obviously a lie.
Yeah. See, in Australia at least, I control bank accounts. My accountant doesn't have access to my bank accounts.
Exactly. The CPA doesn't tell people that. No, yeah, the CPA is not going to say, look, the CPA says you want distribution of funds, I will do this for you. The CPA can't say, well, you can't give money to somebody because you think they're doing something illegal, which wasn't happening, which has been demonstrated. No CPA is going to do that. Goes to Recon $5. What, Nate, are you talking about? Not sure why I kept blocking my super chat. Yeah, I don't. Yeah, YouTube is weird what it picks and chooses what to not allow for a super chat. I don't know, my friend. It is odd. We're talking about Nate Brody, by the way, though.
Todd's just arrived. Someone give me the too long didn't read. Court has made an order to basically give Kyle another 10 days to supply the documents that he said he had in his deposition. And also to give him a chance to respond to Scotty's motion to withdraw. It's for completeness of record more than anything else, and I think giving him another chance to hang himself, basically. So
yeah, I don't think he man, I'm telling you, if he started forging more stuff, knowing that he's already been busted, would makes no sense. No sense.
Yeah, he's not going to do that. No, he's not going to respond. He won't respond. Heard it here first.
Yeah, no, I said it first. Oh, we said it together. Res Instance 510 Australian. Hashtag Kyle lost. Hashtag wrong move, buddy. Hashtag Bulls. Yeah, by the way, wrong move, buddy is going to be going to live on in infamy. Yeah, so this is going to be after the election, which is, oh, man. And also, obviously, it won't be on that same day. So we're looking at probably the following week when he basically does anything. So I was a little off on my projections. I thought he would be doing it this week. I didn't, like I said, I would give you guys the most accurate information. And that was, you know, my opinion, obviously, how I think it was going to go down. But it makes more sense now that the judge wants all this laid out, just like this order, to one, limit, to actually nullify, I guess, any chance of appeal, and to just turn all it over to the DA to prosecute.
I would call this unexpected, but completely expected in hindsight, this order.
Yeah, I should have thought about it too. I agree with you. Yeah. It makes a lot more sense that, because I even was saying the judge, we know Kyle screwed himself in the depositions when he said he had these documents, and he didn't. It would make sense the judge is going to go, oh, really? You claim you have these documents? Okay.
It's a hashtag bullshit, because that's a name that Uni has coined for me. He calls me bullshitinator, which is quite humorous because he's the one that's actually full of bullshit. So
I haven't watched Uni's upload yet.
I heard about that, and they wanted to make, Quiddy's the Sprinkler wanted to make it my nickname, and I'm like, you can use it, but I just knowing where it came from, I don't want that to be my nickname de facto.
Carrie Bronson again, $5. Can someone better at video editing than me make a compilation of the worst Kyle moments sent to Rihanna's quote, better have my money, please? Look, I there's some really good video editors out there. I'm not one of them. I wish I was, because I know in my head what I want, but I don't have the skill set to do it. I admit that. But I think when this is all said and done, you're going to see a lot of content creators scurrying old stuff and really taking things and putting them out there for entertainment value. I really do.
I think Tau City Alpha is going to have a field day.
Oh, I hope that he does. You know what? I anything he needs. I love Tal City. Anything he needs, I'll get to him. Viber Brantley, $5. I have very little money, but I'm trying to lose weight. Oh, dude, I don't want. Yeah, come on. I feel bad, but losing weight is great because I haven't been. I'm actually putting on weight. I gave up. I was like, I'm done. I'm gonna wait till the election. Wait till this is over. Less, I guess, stress. But yeah, I've been kind of eating a lot, stress eating, I guess. And I'm not even under that much stress.
I've lost 6 kilos in 3 months from a new diabetes medication.
I'm up about 5 pounds, actually. Yeah.
It's Trulicity. So it's similar to one of the weight loss. It's like an analog to the weight loss drug Saxenda. So it's really close to that. And it's
so you're down 6 kilos.
I'm down 6 kilos. Yeah.
Wow, I'm up. So hey, want to trade?
No, loving it actually.
There you go. All right. So what do you guys got for questions? Like I said, I don't want this to go very long. This is just really quick to give you guys an idea what the order was about. After talking to our attorney, take it, leave it, believe it, don't, whatever. We're just going to put the information out there, and if people want to believe it, great. If they don't, hey, you know what? I'm tired of freaking trying to convince them. At that point, I just think
tag us in the chat if you got questions, and then I assume we'll finish up in a minute.
Let's see here. Elise, I know that Treat Feline's trying to get a hold of you. So,
Cajun Crustacean. This whole document is basically the judge pulling from the DM playbook and going, "Are you sure you want to do that?
Is this your final answer?"
Well, that was the depositions. I mean, that was really like, hey, okay. Scott, I mean, I gotta admit, Scott was really just getting him to say, look, do you is this really want to do this? Okay, are you sure about this?
He was excited. He was excited about the depositions.
Oh, I'll be honest. The first thing that Scott said to us when after the depositions, people, was that basically he just said Kyle lied the entire time. Kyle just lied. Yeah. That's all he did was lie. That's all he said. Yeah. He says Kyle, all he did was lie. We know that.
Going into it, he goes, "This is a target-rich environment." Like he was loving it.
Oh, he look. This was a dream case for a lawyer. A dream case.
Yep.
So, given that Scotty Forbes Lee is still Kyle's lawyer, doesn't that put her in an awkward position? No. Because does she still represent him? Yes. But
technically, yes.
Is Kyle going to do anything about that? Probably not. Kyle would have to really come up with an amazing argument to why he feels it is undue on him if she left at this stage of the case. And I don't think there's any reason why he would have.
I can't figure an argument out that would actually nullify her request.
Yeah, really, it would be. She laid out 4 really good reasons.
I think if the request is not granted, I think then we'll argue about this later, Steve. But I think if the request is not granted, she then has to approach the court and say he forged.
Maybe
that's the way I read it in the first place. Anyway.
All right. Well, we'll check into that. I'm not going to die on that hill, but I think that by her,
I'm curious.
I think that by her doing that, at least this is America law. You Australians. Completely different, but in America, under Rule 1.16, you cannot violate attorney-client privilege. You cannot tell.
No, I think it explicitly says that you can.
Where?
In Rule 3.3. It says you can even break Rule 1.6.
I'm gonna have to look into that because everything I've said heard on it is they can't.
You should have a Twitter war.
Unless,
you should have a very public Twitter war over it, Steve.
You know what? I'm gonna haunt you for 3 years of your life now. It could be just that. I thought it was if they want her to commit a crime, if they've used the lawyer to help commit a crime, then she has to go. But if it's confidentiality about a past crime, I'm not so sure. But that's a good legal question, isn't it? Though.
Yeah. Oh no. I'll show you what I found the other day, and then we'll have a Twitter war. Yeah, Beatty. Oh, sorry.
Another fucking Twitter war.
It would make sense. It would make sense if he was a Yek creationist.
I again, somebody had told me that, and I found it a disbelief. Jess, I'll show those next stream. I'll save those, but those are pretty good. But yeah, it would make sense that he's just a disgruntled young creationist.
I'll show you what I found the other day, and then we'll have a Twitter war. He does have Beatty. Quite the hate crime for people.
Another fucking Twitter war.
I love that term, by the way. It would make sense if he was a Yek creationist.
All right,
again, any more questions in the chat?
And I found it a disbelief. One sec. Sorry, I had weird. My Twitter line came on feedback, so I continue where you were.
Hasn't Kyle used her to commit a crime unknowingly? Yeah, probably. I mean, he
but the evidence of that crime.
That's a hard question.
The evidence of said crime, which is false, I believe he's going with the falsification of the court, and any specific crimes that covers would be like, okay, it's self-evident. The judge doesn't need her to actually come and say, yeah, he fucking forged this shit, because the judge can look at it and say, yeah, he forged this. This is not what Discover says. This is not what Zell says. This is not what any of these agencies say happened. Yeah. So yeah, he doesn't need her to do that. He's capable of looking at the evidence.
Our lawyer basically said she would have to go to her ethics counsel at her law firm.
Yes.
To figure out what to do. So she is obviously following advice from her counsel as well.
Right, that's presumably.
Yeah, we can kind of say that Scotty Forbes Lee, Kyle's lawyer, has her own lawyer now. So
pretty much.
Yeah. Well, because she's part of a firm, so yeah, she probably And our lawyer actually said he would be he's pretty much convinced that at some point Scotty Lee wrote Kyle an email saying, hey, look, you're not listening to my advice, you're not taking counsel. And so it was called a cover your ass letter, as he put it. That so he can't come back in a narrative to try to say, oh, I had bad counsel, I had bad representation. She covered her ass. $10, 10 pounds from Bunny Wabbit. She says, saw you lusting after BK on Twitter. No idea if it'll cover it, but have one on me. Hashtag no BK in prison. Hashtag Kyle told me some whoppers. That's actually good. Kyle told me some whoppers.
they have some cracking
Bunny
cracking
Rabbit,
Twitter tags.
I give you my word. The next time I get out, I'm pretty sure there's a Burger King around me. If there's a Burger King around me, I give you my word. I will go use that, and I will get Burger King Whopper. I just got to remember where the hell a Burger King is around here.
Yeah, the no BK in prison tag that Reds is running is fantastic. If you search that tag on Twitter.
Yeah, that's such a running inside joke that only a handful of people really even know about, but it's still hilarious.
Oh, really? Right.
What?
Oh, I thought it was basically public knowledge. Anyway,
I don't know. Is it? I don't know.
I mean, Newton talks about it, so
Is it public?
Kyle obviously talks about it.
Okay, well, I really? I mean, I know it's out there, Bull, but I mean, do people really know the whole story behind the whole?
I don't know. Doesn't really matter.
It's for another time.
Oh, you're talking about the story.
The story behind the whole story.
The story behind the BK thing. No, yes. I don't think most people are.
I don't think they do.
Familiar with it en masse. It's
a very inside.
Talk to Reds.
It's a very
talk to Reds.
Yeah,
just Red.
Yeah, just a
not Red.
Yeah, talk to Reds.
All
right.
Cool.
But it is funny, and I do like Whoppers, so I will get a Whopper with that. But I still like the whole Kyle told us Whoppers. That actually is really good. All right. So thank you guys. I'm done. I'm ready to go bed.
She's still shushing us.
Yeah, so we got it, Chesh. I know there's a delay. She's having. This is how strokes happen. I think she's having a stroke. By the way, you guys may not know this, but our friend Trevor Val, the paleontologist, had a mild stroke. He is recovering.
Oh.
He's doing well, but he was lucky because he knew the signs of a stroke, and it probably saved his life. So recognize the signs of a stroke if you're having the headaches and droopiness and slurred speech and things of that nature and pain in an arm. Get help, because we don't want him to die on us, because we actually really like the guy. I was like, look, at least wait till 2021, right? I mean, don't have another death in 2020, because this year sucked.
Yes.
Living dinosaur. Well, then why won't the fuck at this point? Won't he admit it? There's no reason for I think Kyle to come clean at this point. He had his chance. Coming clean now would just help. Would basically just solidify his prosecution, right? So I don't know what advantage it would be, except that maybe, as Sean Hufford points out, maybe this judge is giving him a chance to come clean to lessen any severity for contempt. I don't know, but
Kyle's only option is to be quiet. That's his only option.
I think so as well. Any lawyer would tell him to shut the hell up.
That's a very
Bunny Rabbit's like, get a salad instead. I want to. Oh my God, is that a fat joke, Bunny? I want to. I'm not overweight. I'm not as slim as I want to be, but I'm definitely not overweight. I can eat a Whopper.
They also advise him to comply with the judgment. Like, isn't that something that's?
Comply with the judgment. Sure. Yeah,
you got a judgment against you. You need to comply with that judgment.
You can't turn over documents you don't have, though, right?
Well, no, we know that.
The default judgment. He's got to turn that over, right?
Yes.
He's got to turn the channel over, and
but that's just for contempt hearing. That's just jail. He's looking at jail for that. He's looking at prison for the other kind of stuff.
Yeah.
So
but he still has to do it.
Yes, but really, no, he's not going to turn that over. No, he's not going to show up. He's not going to turn over. He will have an arrest warrant out. Yeah, that's a given.
Yep.
Because Kyle doesn't take good advice. He never has, never will. I mean, he's basically he's very predictable. Even though we can sit there and tell him look at the advice we gave him at the beginning, David. You, me, and Reds gave him very sound advice. I bet he wishes his ass he would have taken that advice.
I told him in January, the infamous occasion where Kyle told me to fuck off, and that's why I went in my time machine and sued him, was in January after the default judgment was filed. And I said, this is what's going to happen. The judge is going to put his default judgment in. There's going to be a contempt hearing. If you don't turn it over, that's jail. And, that's what's going to happen.
Yeah, they still try to think that, Roof was so upset that he was told to fuck off. He's Australian. That's how they greet each other. Like, that's going to offend him? They don't know you at all.
Yeah.
Like, really? All right. My voice is shot. I'm going to call it a day. Again, I just wanted to give you guys a quick update. And if anything else comes through, I'll let you know. But there's not going to be any movement, I think, until November 5th. Kyle's not going to file anything. And again, he does have legal representation still. So we'll see if Scotty helps him out. But I'm not holding my breath on anything.
I would bet the judge and his clerks, whatever, are writing their judgment, writing the ruling now.
Oh yeah. They've already got an outline, and I think obviously they're obviously getting a packet together that'll be sent to the DA. Now I will go on record before I end this. I do have a $100 gentleman bet with Peter Riley from Forbes.com, the guy that wrote the Forbes article. He has bet me that Kyle will not be indicted by at least January 31st, 2022. I believe that he will be indicted before January 31st. 2022, and we don't have anybody holding the money. Is a perfectly gentleman's bet. So if I lose, I will give him $100. Well, actually, he wants me to donate to a certain charity, which is fine. So I want people to be aware of that. So that's on record. I'm perfectly fine with gentleman's bet. I again, I don't think everything has to be contractual. I like honorable systems. I really do. That's what I wanted from Kyle to begin with. I just picked the wrong person.
Yeah, if it's for any decent amount of money, there needs to be contracts and escrow.
Oh, yeah. You wanted to bet $1 million with people, but they were too chicken shit to do.
I would bet every fucking dollar I had. Anyway, RNGD Gaming in the chat. So the C-bomb, the the C word is a greeting in Australia if you're a bit of a bogan. If you don't know what a bogan is, you have to Google that as well. RNGD Gaming has the best GIFs of Unirock on the planet. They're fantastic.
They're really good.
Yeah. All right, let's finish up.
I know you got to go. Thanks a lot, guys, and we'll see you later. Peace.
Cool. See you. Bye.